Thank you. You may be seated. Morning. Yeah. Thomas, they're not right in my face, but then. Good morning, Council. Good morning, everybody. Dumelang. May we start?
Morning, Justice Msaneke. The witness that we're supposed to deal with today, it's Dr. Makgabo Manamela. Her attorneys are outside. I just spoke to them just a minute ago. They had indicated that they'll be here at 9:30. They are here. I have called them to come in together with their client. I'm not sure whether they're still working their way in, but I was told that there's counsel on her behalf who's going to be addressing us on certain issues which they have raised, and I suggest that we give them that opportunity to raise those issues themselves before we can deal with them now. I can't raise them now until they raise them, Justice Msaneke.
Very well. They should come in and let's hear what they are. But is the witness going to take the stand in the meantime?
That is what I've suggested to them, that the witness must come in and take the stand. Thank you, Justice Msaneke. The witness is she's walking in, and the attorney is here. It's Dexter. He will be addressing us just now.
Good morning, Justice. My name is Dexter Selepe.
Yes.
I'm the attorney from ACM Attorneys. Oopsie. We're representing Dr. Manamela, and we are at present, with due respect, waiting for our counsel who is lost somewhere in Hillbrow trying to reach this place. And Dr. Manamela is indeed here to come and address you. There are certain issues that we need, which are preliminary and which we request you to consider, and counsel will address you on those issues. Thank you, Justice.
So counsel is not. Good morning.
Oh, counsel is behind me.
Morning, Chief Justice.
Yes, good morning.
Justice Msaneke, my apologies for being late. It's still tough for a young man from Limpopo to find his way around Joburg.
Yes.
By the way, I'm here. My name is Lerato Mashilane. I'm counsel for Dr. Manamela.
Advocate Mashilani, good morning and welcome. We are all ears and ready to listen to you. I believe you have a matter you want to raise preliminarily or in limine before we start.
That's correct, Justice
But for
Museneng.
starters, is your client here?
Yes, indeed.
Very well.
Before I proceed further, Justice Museneke, I would like to state on record that I've got instructions to actually request a postponement in this matter. And I have reasons to actually convince the arbitrator to an extent that my client be granted such postponement as we request. I would like to indicate that the basis of that request is based on the fact that up to date, my client does not have any information at their disposal to actually prepare herself to stand this arbitration. We understand, and as per my instructions, that there is a volume of document which I've got instructions that it will be just and fair for the person of my client to be given an opportunity with respect to actually get to understand what is in there. And further to that, the difficulty that my client is facing at the moment is due to the fact that there might be a need of further documentation which she might want in order to reply adequately to the advantage of this arbitration. So it is my submission as per my instructions that, because my instructions is that she would like to stand before this arbitration and answer question while she had an advantage of having had been advised accordingly. And also, since this matter is one of public interest, so that the public can get to know each and everything that had transpired. So it is based simply on that particular aspect. My client is happy to stand before this arbitration and give evidence. However, the predicament that she is currently facing, it is as what I've brought to the attention of Justice Museneke.
Thank you. Thank you, Counsel. Let me understand the reasons for the postponement again. Let's try and take them one by one. Okay, let's start off with the obvious and the easier thing. To what periods does your client want the hearing to be postponed? To this afternoon, to tomorrow, to next year? What? Just give me the detail of your application.
To be straight to the point, Justice Museneke, that will depend on the volume of the document that is actually before this arbitration. But we may request to stand it down and get further instructions, and then we give a clear direction. But however, we would also like to bring it to your attention that my client might want to request further documentation from the Department of Health, of which, with due respect, we submit that it might be a bit of difficult. That being the case, we will also seek a protection from the arbitrator that the department actually be of my client assistance with regards to any information that we may need in future. And I don't think that it's something that I can say it here as to how long. We'll request a stand down and then I consult thoroughly and at least get to have advantage of how big the documents
Well,
are.
So
And
you
then
didn't consult with your client over the weekend or before today?
I think that will take approximately, I've just have a look at the document, but I don't want to say something that I want to give a clear indication and direction. And I think it will be fair if we can just stand down for 5 minutes and then I get instructions and to get an idea as to how big is the document that need to be.
Yeah, there are
That-
many other things that you're going to have to clear up. For starters, I just wanted to know, for what period are you asking for deferment of the hearing? Are you looking for a week or 2 weeks or 10 weeks or 1 year or 1 day?
I can,
Have you made up your mind about that or you want instructions on that?
I want instructions. I want to take instructions and also converse that with my attorney. And that will only take some few minutes, 5 minutes or
Well,
to say.
let's go back to the reasons for the postponement. When was the subpoena served on your client?
With due respect, Chief Justice Msenegi, there are 2 subpoenas that had actually been given to my client.
No,
One,
the second one that specified today's date. When was it served on your client?
yeah, maybe to be brief, the second one was served on the 2nd of November.
And today's date is
The 20th.
the 20th of November.
That's correct.
So for the last 18 days, your client knew that today will be a date of hearing, right?
That's correct. But
Okay, let's specify the documents. Let's understand what Dr. Manamela would like to have at her disposal. You say she needs certain documents to study. What documents are they?
to be specific to that particular question, it is not clear now because she have not had advantage of the documentation that is before the arbitration. And that will be informed by the kind of document and the kind of questions that she is actually going to face. And as I'm speaking now, Dr. Manamela had been suspended and her laptop had been confiscated at this stage, which, as per my instructions, there will be information that she will need, in fact.
Can we go to the point, counsel? I ask you to listen to me, please. Which documents does your client seek to have access to?
I've just been given instructions. As I've indicated earlier on when I started to address the arbitrator, one, that my client does not have any information that is before the arbitration. It is my instruction that she will need all the information with regards to all that information and have an advantage to
Let's
consult.
specify the information, counsel. Talking the language that you and I know. What information are we talking about? What are your instructions? What does your client seek?
Currently, Justice Museneke, we don't know precisely what are the questions that my client will be facing. And we understand that there is a volume of document before the arbitration. As per my instructions from client, is that she can't expose herself to questioning wherein she did not have any background information with regards to the information before this arbitration. And I submit with due respect that it will be just and fair for my client to have insight of that particular document that is before this
No, but
arbitration.
specify that. Have you talked to your client? Have you consulted?
I have consulted.
What? You bring an application for a postponement, right?
That's correct.
You're obliged to set out grounds why we should incur all these costs and time wasting and further waiting by the families. There must be a cogent reason in law that moves us to defer the current proceedings. And as you know, and postponement is not there for the taking, particularly for a witness. So you are obliged to persuade at least me why you seek a postponement. So the first thing you mentioned, one, you don't know to what date it should be postponed, or the extent of the period of the postponement. Will give you an opportunity to consult with your client about that. The second is, you say you seek a postponement because of certain documents your client would like to look at. The natural question is, what documents are they? I wouldn't know whether it's fair or not to postpone if I don't know what your client is looking for. So you got to start right there and tell me what stands in a way to give evidence without the documents. But for us to get there, we must know what documents she's in search. Would you respond to that?
Thank you, Justice Mseneke. My answer will be structured as follows. One, and I will still stand my ground as per my instructions, that currently my client does not have any document before this arbitration. And I will go to the second question. The second question was, what document does my client need in order to prepare? It is my instructions that the document that will in fact be given to my client, and that is the request, and I carry instructions to request those. After perusal, which Chief Justice has indicated that is happy to give us an opportunity to consult, then I will know after how long is it going to take to consult with client, then we will know precisely what document we need. At this point in time, with respect, it is extremely hard to indicate as to what document my client might need, because that will be determined by the information or in fact, the information that is before the arbitration, that she needed to have an opportunity to peruse and be advised accordingly. And then, so
Yes.
I think...
Has your client asked anybody for any document before this morning? before now, when you started speaking?
I would like to bring to the attention of the arbitrator that my client had been in contact with the evidence leader, one advocate, Ngucha, to be precise, and there is a situation wherein my client, after having had been given this subpoena, she requested information as to what extent is she expected to answer the questions and any background
But did
information.
you hear my question, counsel? I say, has your client directed any request to anybody before this morning for the documents she now seeks? Answer could be yes or no.
It's yes. I'll say yes.
In what form and to whom was the request directed?
A request had been made to Section 27, wherein a letter was addressed. And Section 27 referred my client to the evidence leaders to say that the evidence leaders are the one who precisely knows to what extent will she be in fact facing, they are in fact leading her examination in chief. And information had been requested from the evidence leaders, but my client raised a concern to say it's the subpoenas from Section 27. Hence, my client requested information in order to prepare. That's when we indicated clearly that we won't be able to proceed without information. And secondly, a letter had been directed to the minister, the acting CEO of the department, HOD, Dr. E. Kinosi, requesting information, to be specific, the laptop that my client was using when she was still under the employment of the department. And that had been clearly indicated that she will need that information in order to prepare for the arbitration. Hence, it had been indicated from the onset that we won't be able to proceed with the arbitration today. That communication had been communicated to Advocate Ngucha, and at some point they requested that my client avail herself, which was yesterday at 8 o'clock at his chambers, and that was short notice. And so we are indicating that the major issues that my client, as we speak, she's happy to stand before the arbitration to answer the question. However, she does not have any information as we speak now, and it will be unjust. It will be unfair for my client to be expected to answer the question adequately, even to the advantage of this arbitration, because this arbitration has a duty. And that duty will mean that my client should be afforded an opportunity to actually have an advantage of all the documentation. If she has to request document, which we believe, as per my instructions, that there might be more document requests from the department. And further to that, her laptop had been requested, which has some information, which we strongly believe, without doubt, that it will be important for her in order to prepare thoroughly.
What else do you want to say in support of your application for a postponement?
May I take? With due respect, Justice Musenege, I would like to be granted that opportunity that we stand down, and then I will be able to answer fully those questions. I think it will be just and fair. And then we'll be able to also try to seek information as to how big is the document that is before this
But
arbitration.
why didn't you get this information, these instructions from your client before the start of today's hearing? Why should all of us, nearly 10 lawyers adjourn, including me, when you have the obvious duty that you and I know, your attorney knows, you know, that you consult with your client at your own time, not during time of hearing. Particularly on a simple thing like what documents she needs, how much time she needs. Why must you consult now? To the inconvenience of all of us.
Chief Justice, as it had been indicated that my client does not know the volume of document before this arbitration. And it will be fair if we are to be given an opportunity to stand
By what
down.
law, just tell me, let's talk about the law a little. By what law is a witness entitled to all the documents before a proceeding? Could you find me the authority for that proposition?
With due respect, my submission in that regard, taking into account the fact that my client had been implicated. There are some witnesses who implicated her, and it will be just and fair. It will be her constitutional right to exercise that the proceedings be fair on her part. She be able to stand her ground and answer questions adequately, knowing exactly what is it that is expected from her. It will be unfair if my client is to come before this arbitration today without having had an opportunity to peruse the document that the question will actually flow from. For an example, one can say Ashliver filed, and then there is document number 2000 for an example, and my client will be expected to answer questions from that particular question. And at this moment in time, it is unfair for my client to be
I'll try again. Let's talk law. Refer me to authority for the proposition that a witness is entitled to what you claim. And not a party, a witness.
Before I
And
answer
that-
Justice, I think I need to lay a ground as before I come to the precise question that had been posed. So, first and foremost, I would like to indicate that my client is different from most of the witnesses that have come before this arbitration. And I will indicate why. That for all intents and purposes, there had been evidence to implicate her. And that being the case, my client can be seen as an accused because possibility is that if there is negative doing on her part, she might face a criminal prosecution. And with respect, and in the best interest of justice, in the best interest of the public to know, and in the best interest of my client as an individual, I submit that on her part, it is different from all the witnesses. And she needs to have an opportunity to prepare thoroughly, taking into account what I've just indicated before.
Are you going to make a legal submission or refer me to authority that supports the request you've just made? You're not obliged to. I invited you to do so. And if you decline, I would understand. Is there anything else you want to say? I
Nothing
have to
else.
give your colleagues to respond. There's a whole panel of legal representatives who have an interest in these proceedings, starting with those who subpoenaed your client. She's here on subpoena, which requires her to answer all questions fully that are posed to her, except if there is reason in law not to answer the question. That's why she is here. She's on a subpoena. You want a postponement, and before I make a ruling on the application for a postponement, I'm going to hear out every interested party in the matter. That's why I ask you, do you have anything else to say in relation to the application for a postponement?
Currently, no, because as I've indicated earlier on, I've indicated that I would be happy, may it please the arbitrator, that at least we stand down. I think I would be in a position to answer some of these questions. So I don't want to answer them in vacuum. I just want to get certainty and then
So
proceed to...
you say you will not be able to complete your application for a postponement until you have talked to your client. Is that what you're saying?
No, I do have an application for postponement, and there is an affidavit that had been prepared to that extent. That affidavit, it's actually based on the submission that it touches a lot on what I've just brought to the attention of
Will the affidavit
arbitrator.
be part of the application for postponement?
That is correct,
Can you hand it up?
as the court. I've been told that it still has to be commissioned, but
I'm sorry, to everybody in here, we've long agreed that we don't boo and heckle witnesses, please, not. Unhappy as you might be, I ask you to restrain yourself, please. And counsel is entitled to make all submissions that he's making now. Shall we please observe that? So there is a draft affidavit. It has not been attested to yet. Is that it?
yes, but that will be attended to should we be given that opportunity to stand down, as we have requested or indicated that it won't be more than 5 minutes.
Advocate Hassan,
Justice, may I?
is the opportunity to respond to what has been said up to now.
Yes.
There are two parts to it. One is a request for a stand down.
Yes.
The other one, of course, the main substantive thing is an application for a postponement. So those are the two things which are before us for the grounds that have just been set out now. And I'm going to give all of you an opportunity to, the question is whether all I should give you an opportunity now or should allow the stand down, after which hear all of you out.
Justice, may I ask you to please switch off one of your mics so that mine, thank you. It's working now. Justice, I would like an opportunity to at least make preliminary submissions in relation to this application that's now being sought. So I would ask to make submissions before we stand down, if I may.
Yes, of course you
And let me begin with the following, and that's, we don't actually have an application yet. Let's start at the beginning. The subpoena was served on the 2nd of November. Subpoena was issued by the clerk of the court, specifying the date on which Dr. Manamela was to appear. Dr. Manamela's non-appearance would be contempt, would put her in contempt. We don't have an explanation, in my view, as to why we have not been served with the notice of the postponement. There's been no notice that's been provided to say they will be seeking a postponement, and there's certainly no evidence to support the notice of motion. So far, the evidence that's been provided by counsel for Dr. Manamela has been from the bar. So this has taken us completely by surprise. I've just been advised that the lawyers for Dr. Manamela have requested my attorney to commission an affidavit that supports the application. It would be a breach of our ethics in order to do that. We are a party to this. We are the party that issued the subpoena. We cannot commission the affidavit of Dr. Manamela in the application for a postponement. So the first thing I'd like to say is that there's no notice. The second thing is that a postponement is an indulgence. It's not, as you put it, Justice, there for the taking. And I'd like to refer Justice Moseneke to the authority for that, and that's National Police Service Union versus the Minister of Safety and Security. And the citation is 2000, Volume 4, SA Law Reports, at page 1110, and it's a judgment of the Constitutional Court, and the relevant paragraph is paragraph 4, in which the court says a postponement of a matter that has been set down on a particular date cannot be claimed as of right. An applicant for a postponement seeks an indulgence from the court. What I would like to also point out is that in that case, and in all the cases I'm aware of dealing with postponements, the postponement is sought by a party to the matter, not by a witness. And there's good reason for why the court has taken that approach, and that's because it's an interest of all that there's finality to litigation. Postponement results in greater costs to the parties. Postponement also results in waste of time. And it has an implication for the fairness and justice to the parties to the proceedings. In order for the applicant to succeed in her request before this arbitration, she has to show good cause. She also has to show why it would prejudice her. I'll refer your justice to two further cases. The first one in relation to good cause, and that's Prasad, P-E-R-S-A-D-H versus General Motors. And it's 2006, Volume 1, South African Law Reports, at page 455, and it's cited as a Southeastern Coast Local Division, and it's at page 459, in which the judgment explains the need for good cause. The second judgment is Myburg Transport versus Botha, 1991, Volume 3, South African Law Reports 310, page 310, and it's the Namibian Supreme Court. And what was at issue in these judgments is the weighing up of prejudice versus and good cause versus finality of litigation and fairness and justice to the parties
And
involved.
in all of those, the cases relate to parties.
They all relate to parties, not relation to it. I'm not aware of any precedent that permits a witness to proceedings to be provided with questions in advance and to be provided with the evidence upon which those questions rest in advance. I'm not aware of any such precedent, and I invite my learned colleague to provide us with precedent for this very, very unusual request. But most of all, Justice, it comes on the morning on which Dr. Manamela is due to appear. And we are not provided for reasons as to why that is the case, why it was not possible to consult. I'm sure the evidence leaders will give an explanation as to their contact with Dr. Manamela, why there was not an opportunity to consult beforehand, to provide notice to the parties that this application would be forthcoming, and to provide an affidavit upon which the application rests. None of that is before us. And this is on subpoena. This is not an ordinary witness either. My learned friend is quite correct that she's not an ordinary witness. This witness had to be compelled to appear. And our last correspondence with the witness was that the witness would be appearing today at 9:30, and no notice was given of this that we are now dealing with. The other thing I'd like to say is Dr. Manamela is not on trial in these proceedings. She's a witness that is meant to assist the arbitration in order to come to the bottom of what answers we are seeking in this arbitration. The merits of the case have been conceded. What we seek are answers, and that's why we would submit that Dr. Manamela must proceed with her testimony today. Finally, to the extent that this has caused a delay and to the extent that there is any postponement that is granted, we seek costs on a punitive scale from the applicant for postponement in her personal capacity. Thank you.
Thank you, counsel. Advocate Krause.
Thank you, Justice Moseneke. As I understand, there's two issues before the forum at the moment. The one, the request that the matter stand down, and the other, the request that the matter be postponed to an undetermined date. And as I understand it, the issue raised, let me start with the first issue. If the matter is to be stand down, of course, in the fairness for the witness, we will have no objection to that. But merely to take a brief instruction. As to the application for postponement, we will oppose that. And I will try to address this court on two issues: fairness to Dr. Manamela and fairness to the rest of the parties. Now, we know that the subpoena was served on the 2nd of November. We know that there was a letter addressed to the evidence leaders on the 12th of November asking for legal costs. No issues of today's magnitude were raised in that correspondence. The further correspondence that we've received, and we've received that only this morning, was a letter by the attorneys for Dr. Manamela dated 17 November, and that was emailed on the 18th of November, which is Saturday at 13 minutes past 7 in the morning. So it's a correspondence that reached the evidence leaders, according to what we've received on Saturday morning, stating that the subpoena was of Section 27 was not in good faith, but that the witness wanted to tell a story because of all the lies that has been told. Similarly, there was an affidavit, email forwarded to us dated the 18th of November, which is Saturday, just after 8, to Dr. Kunosi asking for the laptop. Now, if one look at the fairness to Dr. Manamela in all of this, it's quite clear that she was given enough time to deal with these issues. She did not. If one look on the other side to the fairness to the rest of the parties and to the families that are attending this, it's quite clear that any postponement will be totally unfair to them. And as my learned friend has pointed out, it's for a party to ask for a postponement, because if a witness is not available, that party must ultimately bear the costs. It's never a witness that can ask for a postponement. So in our submission, this court should refuse any further postponement of the matter. Thank you.
Very well. Advocate Groenewald.
Thank you, Justice. Justice, I would not like to reiterate everything my colleagues have said, but I think they are on the point with their arguments. The long and the short is Dr. Manamela is not a party to the proceeding. She's been subpoenaed to testify. So the application for postponement is based on the fact that she wants to prepare herself for testimony. The fact is she is a witness that needs to answer questions. She played a central role in the Gauteng Mental Health Marathon project, and it's unclear to what extent she wants to prepare herself. With all due respect, Justice, it seems like this is a fishing expedition to prepare herself and to evade difficult questions. Unfortunately, witnesses are required to answer difficult questions. So there's no exceptional circumstances here, and the prejudice towards the witnesses or towards the family members by far outweighs any prejudice which Dr. Manamela might stand to suffer. The long and the short is, Justice, we do not oppose if Dr. Manamela wants an opportunity to consult with her legal representatives. We don't oppose a 10-minute break to get further instructions, but in respect of the application for postponement, we will vigorously oppose such an application, and we reserve the right to peruse the affidavit, which we haven't seen up to date, and to respond thereto if Dr. Manamela's representatives persist with this application.
Do I have a proper application before me?
There is no proper application before you, Justice. That is also part of our submission.
I mean, aside its merits.
Indeed, so well, Justice, there's nothing been filed on either of the parties. We haven't, as my colleagues indicated, we haven't even received a notice that they will bring this application. So the exact grounds for the application is extremely vague, Justice. We have heard simple issues of fairness. To what extent fairness plays a role, it's unclear, because the witness seems to want to peruse the documents. She's either an author of most of these documents, or she's the recipient of most of these documents, or she has been a party and a deponent to affidavits. So it's unclear why she would not have knowledge of the documents that is part of these proceedings. Justice, so with all due respect, we cannot understand the argument, but the fact is it's without merit, and we submit it.
And would she be entitled to see every document she's referred to?
She is not entitled to see any document and every document, Justice, because she's not a party to these proceedings. She's a witness. It's as plain as simple as that. And I think that is where the argument, that is the high watermark of the argument. She's not a party to these proceedings. She's a witness. She's been subpoenaed to come and testify, and that is the end of the matter.
But while she's in the box and a document is put before her, she'll have the opportunity to look at it, isn't it? And to read it.
Indeed so, Justice. And to the extent that she doesn't know the document, or she wants to dispute the authenticity of the document, she's entitled to do so, I submit, as a witness. And she's entitled to protect herself to that extent. And if she has another document which she says will refute the evidence presented to her, I do not see why she cannot be afforded the opportunity to present a document. So I can see no prejudice to the witness whatsoever, Justice.
Very well. Advocate Nguchana.
Thank you, Justice Msaneke. The facts have been touched by my colleagues. What I want to reiterate here is that we are correctly dealing with a witness. That is one. What is before you now is an incomplete application for a postponement. That is an application has been addressed to you that one, an adjournment should be granted so that further consultation should occur with the witness so that we can be properly addressed. And one of the outstanding issues is the affidavit, which is currently unsigned, which I assumed will form part of the basis of this application. That is true. Then the other is the actual postponement of the witness testimony, that is today. You have not been consistent with the fact that the application is incomplete. We have not been furnished with particulars as to which date this witness evidence ought to be postponed to. So to that extent, it is still incomplete. We are still in the dark. Those are the issues. Then, insofar as the question you had persistently asked counsel on behalf of Manamela, as to when were these documents requested and or whether were they ever requested and so on. The question has been referred to in brief by my colleague on behalf of Section 27. The only time that we land with the specifics that there are certain documents which are required, in fact, this is not it was not in reference to documents. It was only on Saturday morning when that email was sent or directed for my attention, and the same led...
Can you put the date on record, Saturday morning?
That is Saturday morning on the 18th of November, and the letter is dated 17 November. Dr. Kinoshi, who was copied the correspondence together with me, also received the same letter with the same contents. I will hand up a copy of, that is the letter. I have made copies. Basically, the letter addresses or raises a number of issues, which I had summarized to be that the witness complains that she will be ambushed. And my response, that is to the letter, immediately thereafter was that I do not understand why the witness will be ambushed, because one, she was a project leader. None of us were involved in this project. She has intimate knowledge of what has occurred or has not occurred. She was there that is from the onset. So she ought to know what has been done or what has not been done as a project leader. That is one. And then two, in the event that there is a concern that she may be ambushed, I offered that on Sunday morning, I will be available throughout the day to consult with her, to prepare her. And the basis for that was that she was not going to be led by her legal representatives, but she will be led by the evidence leaders. Then, that being our responsibility, we need to consult with her. But if she doesn't want to consult, if she wants to expose herself to cross-examination or leading evidence without being prepared, that is entirely up to her. And the response to that was that no, and the response was curiously the following day.
So you offered to be available on Saturday, the 18th of November?
Sunday, throughout.
Sunday the 19th.
Sunday the 19th. I offered that, no, Sunday I'm available. I can consult with you. Please provide specific times and revert to my proposal. The response to the proposal was that the proposal was that is the proposal was made. In fact, the timelines that was given was too short. So the notice was short. That was refused. Instead, the answer was that, no, we will meet with you at 9:30 on Monday morning. That is why we are here today. That is why now we are dealing with an application which is incomplete. That is why we have now a witness who is apparently completely unprepared, because one, she has refused an offer to consult with the evidence leaders. As a witness, she ought to consult with the evidence leaders, Justice Msanek. So my be that is may, whether you grant that is the opportunity which I support it, that the opportunity to be granted for her to further consult with the legal representatives. Those are the issues, those are the facts, they can't change, Justice Msanek. And
who should I say or order to pay the costs of the postponement?
Precisely, there are cost implications involved, huge cost implications involved. Unfortunately, it's the government that is going to carry the tab of organizing this hearing for today.
The government?
The government would incur the cost, and as well as the parties as well. They will incur the cost. So there are huge cost implications involved.
We're in an arbitration. There are parties
True.
to arbitration. If we were to postpone,
Yes.
they've reserved these dates for this week,
Correct.
several days to hear Dr. Manamela. Who should I order? I'm inviting argument. Who
Correct.
should I order to pay the costs of the parties for a deferred hearing?
Justice Mthanek, the witness is here, that is by way of a subpoena. That is one. And the witness is present for purpose of tendering evidence as a witness. And the witness says that, no, I'm not going to comply, or I'm not ready to do the purpose for which I was called here. And it is the responsibility of that witness, Justice Msanek. I do know that the witness is not a party, but the witness is here by virtue of a subpoena. There are consequences. If she were to, say, decide now that I'm not going to abide to the subpoena, there are consequences to that. That is, a warrant will be issued. Why can't cost be issued?
Yeah, you see, over the years, the judicial system knew quite well that if witnesses were to have the authority to call for postponements, justice would almost never be done.
Correct, Justice.
And the parties would prepare themselves to the hilt, and witnesses could call the party off. They could call the game off by just appearing and say, I'm not ready, I need more time. Is there anything you want to say by way of submission there? Whether
Yes.
the judicial system at all permits witnesses to seek postponements?
Yes. Otherwise, if witnesses were to be permitted to do that, Justice Msanek, then witnesses are going to direct proceedings themselves. Then the parties are not going to be responsible for the progress of proceedings such as this.
Hence the question, who then bears the cost?
The
If a
witness-
witness wakes up one morning and says, I need more, I want to read more. Who pays those costs?
The parties do pay those costs, but now it should be the witness, Justice Msanek.
Thank you. Any more submissions?
No more submissions.
Advocate Witamo.
Thank you, Justice. There are two issues which have been raised. The first being the request for an adjournment so that my learned friend on behalf of Dr. Manamela should be able to take instructions. The second issue is in relation to a request for a postponement. Justice, what appears before us is that the application for the postponement is not complete. And from what my learned friends have already said, they are not opposed to an adjournment being granted to counsel on behalf of Dr. Manamela. What we have also heard is that the affidavit in support of the application is in the process of it being commissioned. So for now, we are also not opposed to an opportunity being given to counsel on behalf of Dr. Manamela. What he has said is that 5 minutes should be able to complete his instruction. So if that can be granted to him, then we'll be in a better position to appropriately deal with the application for a postponement. Where we are now, we don't have that application. So if that 5 minutes can be given, and then we'll then be able to resolve the second issue relating to the postponement. Because what we will be submitting now will be premature in view of the fact that that application is not before these proceedings. So let's allow the application to be complete in its form and with submissions. And then we'll then be able to resolve the second aspect.
When will the application be complete in its form?
Well, from what we have heard is that like the request has been made that 5 minutes should be able to be sufficient for us to resume and then deal with the application.
So what are you saying to me, counsel? You'd like to have another bite once we've adjourned for 5 minutes?
Well, it can only be appropriate for us to have a response to the application which is complete. So we will not be making submissions in relation to an incomplete application.
I hear the submission. We're back at you, counsel. You have an opportunity to reply in the light of the arguments you've heard from your colleagues.
That's correct, Justice Msenek. As I've indicated, and my colleagues are not contrary to me being granted that opportunity so that I can be able to answer adequately and deal with these issues once and for all. And then we go forward with this arbitration. So I think it will be fair that I be granted that opportunity to consult my client. And I've just been given an indication, I think, as I've indicated earlier on, that 5 minutes, but an indication that 10 minutes will suffice. I don't know if there's any objection.
That's a 100% increase. Very well, but you don't want to deal with any of the other substantive submissions that were made by other counsel for the parties?
I will deal with them after the adjournment.
After your adjournment.
Because I have to highlight to Chief Justice the reasons why we say as it's...
The last time I heard, I was Deputy Chief Justice.
My apologies for that, Justice Mseneke. But the issues that I would like to have an opportunity to indicate and give grounds and reasons as to, since it is apparent that my client is different from most, if not all of the witnesses that have to come and give evidence before this arbitration. And I will lay grounds and give reasons and substantiate as to why it will be just and fair for my client to be granted an opportunity to actually prepare herself.
And you should, when you come back, you should also make submissions on the law about witnesses and postponement. I'd like you to make submissions about what order I ought to make in relation to costs if a postponement is granted. You must make submissions about how long the postponement should be. I want to hear precise submissions about what documents you say in their absence prejudice will flow. I want to hear submissions from you about what prejudice you say your client will suffer as a witness. And I'd like you to hear submissions about prejudice to the parties and in particular to the family members of the deceased. Each one of those points I'd like to hear from you. So when you take instructions, take full instructions on all of those issues. And lastly, I would like to hear submissions about the delay and the reason for the delay. Emails flying backwards and forwards on the 17th and the 18th before a hearing of the 20th. And I want an explanation about the delay between the 2nd of November and the 20th of November. So I just lay them out to you, Council. I want to hear you on all of those issues, which will enable me to properly consider the application for a postponement. We are adjourned for 15 minutes.
Good morning, everyone. Can you please make sure that we occupy all the chairs? Don't leave spaces between you. Like, can we do that when we return? Thank you.
Thank you. You may be seated. Thank you. Advocate Marilane, are you ready to proceed?
Indeed so, Chief Justice. I don't know where to start. Should I phrase it myself, or the arbitrator would like to give direction as to when do we start and where do we start, so that I can deal with specific issues one by one. But I would like, if I'm given the opportunity to start myself, I will start with the issues that had been raised by my learned colleagues. But before I go there, as I've indicated earlier on, that I would like to bring to the attention of the arbitrator that my client is in fact different from all the witnesses that have came before this arbitration. And I would like to bring it to the attention of the arbitration, to the arbitrator further, that there is a possibility, taking into account as to how are these proceedings going to unfold, of my client facing a possible criminal trial. I would also like to bring it to the attention of the arbitrator further that there is a disciplinary hearing that my client will have to face.
A criminal trial for what?
Possibility.
What possibility? Of what crime?
I would like to bring to the attention further that there is in fact a decision that had been made, that being the decision wherein my client was actually appealing the decision of, or the report of Dr. Makgabo of the ombudsman, so to say. And in the appeal had in fact been dismissed, and it had been recommended that my client should actually attend to the disciplinary hearing that had been scheduled for the 4th until the 8th of December. And in that, in his ruling, paragraph...
Well, before you get there, you said to me your client may possibly face criminal charges.
That's correct.
And I just want you to elaborate on that. Help me understand.
So,
what charges would they be, and about what
there is
offense?
There is allegations that she tried to conceal some of the evidence as per that particular ruling that had been given by the Honorable Judge Mwepe, being the chair of the ad hoc tribunal, dated the 27th day of October 2017. So the emphasis of this point is on the fact that it will be fair and just for my client to be given an opportunity to have advantage of all the document and ensure that taking into account that the evidence that she's going to submit or to bring to the attention of the arbitration may be used against her. And that arbitration having the disciplinary hearing, as we speak of today, having had been said, we believe that the evidence that she's going to give will be also used in that particular hearing. And that being the case, I submit and I
The
stand by my
evidence
submission.
she's going to give will be used in which hearing?
The disciplinary hearing, which she's going to attend from the 4th until, scheduled from the 4th until the 8th of December.
Yes.
And I submit that, taking into account that currently as we speak, there are two parallel sittings, being this arbitration, and there will be also the disciplinary hearing, wherein they are based on the same facts. I submit that that makes the case to be different, and that makes my client to be different from all the people who have came to give evidence before this arbitration. And I will also indicate in conclusion that, as one of my learned colleagues had indicated,
And the
that
difference is that she has to go before a disciplinary hearing. Is that the submission?
that is the submission.
Any other difference?
Another difference, it's what I've already indicated, that possibility of a criminal prosecution. And
As to what possible charges might she face? I'm yet to get an answer.
I think I've already answered that.
Oh, I apologize. Would you tell me that again?
Thank you, Judge. There is an allegation that my client had concealed evidence, and the Honorable Judge indicated in his ruling as well that
So let's reduce our words. The criminal charge you say she might face is a charge on concealment of evidence. Is that it?
yes. So that being the case, because that might be a decision to be taken at the disciplinary hearing, should that be the decision. However, my submission is that, as I've indicated earlier on, that my client is different from the rest, is that she needs to get the advantage of the information and prepare thoroughly so that she comes before this arbitration and assist the arbitrator to reach a fair and a just decision. And my submission, as it has been indicated, that the issue of the delay.
Your client will be asked to testify about things in her knowledge.
That's
She
correct.
won't be asked questions about all sorts of things out there. It will be about decisions she made as an office bearer. It will be about matters within her personal knowledge, like any other witness. Why are the documents necessary? What documents? You are yet to tell me what documents are they.
Yes.
What are they? What documents?
Currently, I can't tell this arbitration the precise document that will be requested by my
I gave you an opportunity to consult so that you can gather that
I've consulted,
information from your client.
I've consulted, and I will indicate why. As we have indicated, that will depend on the decision of the of justice as to what we request information. of which is before the arbitration, for my client to actually have an advantage to consult with a legal representative and be advised accordingly. And that being the case, we submit that it will be fair and just, taking into account what I've brought to the attention of the arbitrator, that the possibility of criminal charges might be there. So that being the case, I submit that it makes my client exclusive in the sense that her evidence needs to be well considered. And I further submit that, as it had been indicated, it will assist the arbitrator to have more insight of what precisely had happened. And my client is actually happy to give evidence, but her request is that she needs to have information, she needs to consult, which I submit that it's fair under the circumstances. All the files, I see there is quite a lot of files here, and I've indicated earlier on, what if the question comes?
She may not be entitled to any of those documents. Your client is a witness. She's not a party to these proceedings. Is it not so?
That is correct.
Where have you ever had a witness saying, give me all the documents you have? I want to see them before I tell you what is in my personal knowledge.
But I was to address that particular facet.
Well, you've got to do that. The day is running out. You've got to do that.
Thank you, Justice.
And I've invited you to give me legal propositions that support the request you are making to help me arrive at a just decision. Wherever have you had a witness say, give me all the documents you have, I want to see them beforehand, because why? You have to have some compelling reason to get us there. And I'm listening. She might be charged, you say, for concealing certain information so alleged. I've listened to that. And what makes her again different? She's got a pending disciplinary hearing that will come up sometime in December. I've heard that. I suggest you make all of your submissions. Let's hear the other parties and let me make a ruling.
Yeah, and another issue that I want to bring to the attention of the arbitrators, that there is actually the case of that being the case of the Supreme Court of Appeal, the Law Society of Cape of Good Hope being the appellant, and Michael Watin and so in this case,
Law Society and who?
it's the Law Society of the Cape of Good Hope and Michael Watin Randall. It's a Supreme Court of Appeal judgment.
Yes, the full reference.
The neutral citation, as the
Yes.
parties ever have indicated, and then 341/2012, in brackets 23, SACA 36, and the date is the 28th of March 2013. That's the day up, the date wherein it had been delivered. So what I would like to bring to the
There is
attention,
authority for which proposition?
it is with regards to the issue of a possible criminal charge that my client might face. However, in this case, this gentleman, Michael Watten Randall, was an attorney who had been, wherein there was allegations that misappropriated trust monies. However, there were civil litigation against him, and in the same time, there were criminal litigation against him, wherein he made an application to stay the civil proceedings against him. And the court granted that the Law Society of Cape of Good Hope, having had brought the application to strike him off, appealed that decision. That's when it went to the SCA. And the SCA indicated that in a situation wherein one is compelled to actually state something, and that being the criminal case, the respondent in this matter has actually been granted, because there was a counter application wherein the court granted that, actually dismissed the application of the Law Society, indicating that wherein a civil trial is running and there is a pending criminal trial, they should stay the civil matter pending the finalization of the criminal trial. Currently, there's no criminal trial.
Is your client the same position as Mr. Rendell?
No.
Is she a party?
My submission is that no, but the inference that or my submission with regards to that is that there is that possibility. And it brings us back to the issue of my client having to come here without having been prepared and give evidence. And I submit that on the point of law, taking what I've brought to the attention of the arbitrator, that being the issue currently, I submit that it is fair.
Let's assume your point is right in law. Why didn't your client prepare in the last 20 days? 18 days, to be exact.
My submission with regards to that, my client from the onset indicated that.
Which onset? 17th of November? Is that the onset?
With due respect, Justice Mseneke, there was actually a situation wherein my client, with the assistance of the attorneys, would actually get hold. I've indicated earlier on that there is a letter that had been addressed to Section 27. And to be specific with regards to that letter, she wanted to know exactly what is it that she will be facing. And it takes us back to why client should be given such an opportunity. She's a witness, of which I understand that will be incorporated or flow from my submission with regards to her being a different witness under the circumstances. And further to that, she's facing a DC, and it could possibly prejudice her. The DC, as I've indicated, will stand on the 4th until the 8th. And every evidence that she's going to give, without doubt, will also be used in the DC. That being the case, it put my client in a different standing, wherein the initial submission and request that the postponement be granted and information be granted.
And is this a departmental disciplinary inquiry?
That's correct.
Has she been otherwise criminally charged?
She had been charged.
No, has she been criminally charged in the criminal justice system?
Not at all. Not at all.
You're talking about an inquiry, a disciplinary inquiry within the department?
That's correct.
Very well. Are there any further submissions? I have to hear your other colleagues, and we have to
Yeah, with regards to the issue of the time, there has been engagement, but at some point it was discovered that the subpoena did not have adequate information wherein a letter had been addressed to Section 27 as well as the evidence leaders. That's wherein it actually flow from there and takes us back.
Have
to,
you ever
to
seen
the
a witness ask for requests for further particulars on a subpoena? Have you ever seen such a thing?
I will submit that this witness, as I've indicated, is different, and I
Okay.
still stand my ground.
No, I'm asking a different question. As a matter of law, have you ever seen any witness write to the issuer of the subpoena requiring further and better particulars?
No.
So why would such a procedure be appropriate in this case?
It will be appropriate due to the fact that during the arbitration, there is actually witnesses who said something against my client. And that being the case, my client needs to adequately respond to those allegations. That is the only chance wherein my client will have to deal with this.
She'll have ample opportunity, isn't it so? I'm here presiding over these proceedings, and every witness has to be treated fairly, and that's an entitlement that the law puts up there. That's why there'll be a presiding judicial officer or an arbitrator.
Yeah, but what I'm trying to indicate is that my client have never had a chance to actually cross-examine. And the only way
Has
upon
never had a
which
chance to do what?
my client, as per the proceedings, the arbitrations, won't have a chance to cross-examine them. And the only chance wherein justice can prevail on her side is to be given that opportunity to answer adequately to those allegations. And it will only be in a situation wherein she's given the information and be given enough time to prepare and reply adequately there. And she is, I will submit that she is portrayed as an accused or a criminal. Hence, there
She's
is...
portrayed as an accused or a criminal.
Yes,
By whom?
As I've indicated, my thing. That people who have came before this arbitration have actually made adverse statement against my client and misrepresented fact. And that being the case, as I've said, and I will still stand my ground, that it will be fair that she be granted an opportunity to consult with a legal representative and be able to reply.
But you are here. He's got an attorney, he's got an advocate. You knew for the last 18 days this day was going to dawn, and you had the opportunity to consult all the way. What opportunity? Can you explain that to me? Opportunity to do what?
Unless the arbitrator decide otherwise. But my instructions, as I've indicated, that though there is an impression that my client is not going to be given the information that she requires, being the information before the arbitration, it will be just and fair for her to actually...
How long have you been practicing? Have you ever had anybody ask a court, give me all the information you have before I testify? And I've invited you to give me authority that entitles a witness to that. Of course, she can meet all the legal representatives she requires. And before time, she could ask for information. if she so seeks and applies herself to the best of her ability. But on the day that she has to testify, she testifies. So, wherever how do you support the procedure you suggest I adopt?
My submission was based on the fact, or on the submission that I've made, that this is actually, my client is a different witness altogether. And I won't be taking that submission anywhere further. That will be
Sure.
the decision of the arbitrator.
Thank you. Do you have any other further points?
Other issues
Other
with regard
submissions to make? Yes.
to the issue of prejudice to parties and everyone, including my client. I submit that the arbitration has a duty to actually hear everything and the unfolding of the event. And my client, as I've indicated earlier on, she is happy to do that, but need time in order to do justice so that even the family can get to know exactly what transpired, which I submit that it will be fair, and it's also one of the duties that this arbitration.
Don't you think in the witness box she can tell me exactly what she needs on her own? She can tell me why she can't answer any particular question, and she can tell me why, what happened in the matter. Why is that prejudicial?
The prejudice is based on the fact, one, is that there is this disciplinary inquiry and there is this arbitration based on the very same fact. And that being the case, it makes my client exclusive because the evidence that she's
Your
going
client
to
can
give,
tell the truth in this hearing and go and tell the truth in the disciplinary inquiry. And that's what witnesses are there for.
that's correct.
And if they feel they are likely to be incriminated, the law protects them.
And that's
And any witness can scream and say, I require protection against self-incrimination. The law is quite clear on that. But the remedy is not to refuse to testify. We know that as a matter of law. Isn't it so, counsel?
And with due respect, I agree to that.
Sure, thank you.
However,
but do you have any further submissions? We're spending quite a bit of
I
time
want
on
to
this.
close, I think. No further submission.
Yes. Remember, you're entitled to make your submissions. I just want us to move to another one. So I don't want to stop you in your duty. Very well, we've had, and the affidavit, has the affidavit been handed up? Are you going to give me an affidavit at some stage?
I was made to understand that there is one before.
I see.
Just,
Okay,
I
counsel.
beg you to hand it.
We should mark the affidavit what?
And maybe, sorry to interject, maybe lastly, we didn't deal with the issue of cost justice.
Yes.
Which I think is one of the aspects which need to be dealt with. My submission in that regard is that the department or the state had accepted liability in this case. And the reason behind my client seeking postponement as a witness was for her, as we have indicated, that she would like to give evidence and in well details and unpack all the things to the best advantage of all the interested parties. That's the basis upon which the application is founded.
And that submission is welcome, counsel. You can see it makes me smile to know that somebody in that important position is prepared to come and tell us what happened. because we can't conclude the arbitration unless we hear the key actors. So I'm happy to hear that submission. What I wait is the but. Is there any but to the submission? Your client is ready and prepared to testify in full detail. That's what you've just told me.
Yeah, that but is that the foundation of this application, adequate time to prepare. And if the decision is that she's not going to be given any information, that is fine, but we are happy, as we have indicated, that we requested the laptop from the department, and that laptop had not been provided to her. And that is one of the sources of information which has an important document for her to actually reply to everything that she will be subjected to adequately. And further to that, should we be granted a postponement, that an order be made that the department, if she need any information, which we are going to request, I know will request information, should be of our assistance and grant us that information. It's not to her own advantage.
You were talking about costs, so you know that. Now you talk about something else. Council?
Yes, with regards to cost, I've made
Who should
my
bear
point.
the wasted costs of the postponement?
My submission is that
Who's going to pay all these advocates and for the days which are already reserved all of this week when we're going to hear Dr. Manamela? Who's going to pay their costs?
And unfortunately, my submission on that aspect is that the state has to pay the costs. And I will give the reason why, as I've did. The reason is because the state had accepted liability. And the postponement is not being sought to prejudice anybody. It is in fact made to an extent that it will, that particular time will be utilized effectively to the assistance of the arbitrator to reach at a fair and just decision or findings. That is exactly the
Does the
concern of mine.
affidavit tell us whether a request for the laptop was made before this weekend?
No, a request for the laptop has been made. There is a letter that had been attached there too. Just for
Take me to
reference.
that letter. I see paragraph 11 tells me that the letter was addressed to Dr. Kinoshi on the 17th of November.
Justice, my submission in that regard, other than this letter that had been attached there to, in the applications that had not been made, this was in fact the second request for that laptop. The first request was made in respect of her appeal at the tribunal. Hence, we have indicated, it was stated in this one. It's actually a bit of
Counsel, show that to me. Just take me through
in the application that
in
had
the
not been-
affidavit before me. Just show me what request was made for the laptop.
It is attachment number D, that being the letter dated the 17th of November addressed to Dr. Kinosi. That paragraph 1 read that Dr. M.J. Manamela, our client, has been submitted to appear before the alternative dispute resolution on the 20th to testify on issues in the subpoena pertaining to the death of mental health care users. And paragraph 2, Dr. Manamela requires access to a work laptop which was taken away from her when she was placed on precautionary suspension. The laptop contains crucial information which will assist Dr. Manamela in a preparation both for disciplinary hearing and for putting together a report or a statement to be presented to the ADR arbitration.
Is the date on the letter correct? 17th November 2017?
That is correct. Hence, I've indicated that this was a second letter that had been addressed, which I don't have in my position.
Where's the first letter? You say it's not attached to the affidavit.
It's not attached, and it has not been alleged in this affidavit.
Is there anything else that you would like to say?
No, there is nothing else other than that. That particular letter, that being the first letter that had been, wherein a request had been made, can be made available.
Now, I'm looking at the notice of motion. That request to doctor of the laptop was on the 17th of November, I gather. And the record of witnesses, what does that mean? You mean the record of their evidence, right? Was
Sorry,
that ever,
Justice.
was that
Sorry.
ever requested?
I'm very sorry to interrupt, but we haven't been provided with a notice of motion. So we're unaware of your relation to what your questions are directed.
Have the parties not been given a copy of this notice of motion?
I thought because we requested someone to make the copies, I thought that had been given to them. My apologies. Yes, Chief Justice. May the question be repeated again? It was with regards to the issue of paragraph 3.
Yes. If you want to talk to your attorney, you've got to excuse yourself so you don't leave me hanging.
No, I'm not. What I will bring to your attention, Justice, with regards to that, is that at least, even if not all the...
I ask you the question, did you ever request for the record of proceedings?
No. In short, no.
Yes, many other people who are not even parties here have asked for the record and we've made it available. So you've never asked for it until in this notice of motion. In other words, this morning. Anyway, do you have any further submissions to make?
No further submission.
Right. Counsel, we have to repeat.
Thank you, Justice.
Is there any further submissions to make in the light of the fresh submissions?
Yes, there is, Justice Moseneke. Beginning with the affidavit. At paragraph 9 of the affidavit, Dr. Manamela confirms herself that the subpoena was served on her on the 2nd of November 2017, requiring her to appear on the 20th. Her first correspondence to any of the parties was a full 10 days later. Requesting information, it would seem, to assist her in her preparation as a witness. Full 10 days later, on 12 November, she addressed a letter to Ms. Umunyana Rujeje of Section 27. None of the correspondence, there's no evidence of correspondence by Section 27 in response that is attached to this affidavit. At paragraph 11, Dr. Manamela says that she wrote to Dr. Kanoshi, 17 November, so 15 days now after the subpoena is served. A full 15 days, first contact is made with Dr. Kanoshi to say she would like her laptop. Moreover, if one has regard to that letter, it states in paragraph 2, and it's annexure D to the affidavit, it would be appreciated if the laptop could be made available to Dr. Manamela by 12 noon on Monday, 20 November 2017. So by 12 noon today, fully knowing that she was required to testify at 9:30 a.m. today. I'd also ask Justice Moseneke to have regard to annexure E to the affidavit. It's annexure E, but it's the second page. And halfway down the page, it's the email information which says sent Saturday, 18 November. So while the letter is dated 17 November, it would appear that the letter was actually sent on the on Saturday, 18 November to Dr. Kanoshi and copied to my learned colleague, the evidence leader. I'd also like to draw the Justice's attention to other aspects of this, but I don't want to make too much of it. It is, however, relevant that Dr. Manamela, in paragraph 2.8 and 3 in particular of the letter 17 November 2017, makes a series of allegations against Section 27. But this letter was never provided to Section 27 or copied to Section 27, and there was no opportunity to respond to that. At paragraph 15 of the affidavit, it's the first time we have some legal submission as to the legal basis for the request for a postponement, and that is with reference to the Constitution and Dr. Manamela's right to a fair trial. That's at paragraph 15. However, this is a woeful misapplication of the right. It's a right that is available to arrested, detained, or accused persons. The fact that there may be disciplinary proceedings pending against Dr. Manamela is not relevant. Those are not criminal proceedings. I'd ask your Justice not to have any regard, therefore, to the reliance on the right, Section 35 of the Constitution, the right to a fair trial. Although the right hasn't been mentioned by number, but I'm assuming that that's the right that Dr. Manamela is referring to. Finally, Justice, in relation to the Randall case that we've been referred to in argument, I'm afraid to say that this is either a woeful or willful misunderstanding of the reading of the judgment in Randall. That case involved proceedings against an attorney civil proceedings in which the attorney had already been charged separately with criminal offenses. So there were criminal offenses, criminal proceedings pending, which is not the case here.
And the attorney was a party.
Secondly, the attorney was a party to the proceedings, which is not the case here. Third, even in relation to the merits, assuming that Dr. Manamela could pass the hurdle of being able, the hurdle of the fact that there aren't criminal proceedings that are pending, even if Dr. Manamela could rely on some penumbra of the right to say that it would not be fair. At paragraph 16 of the Randall judgment, the court made it very clear that it's really in circumstances where there will be an element of compulsion in the proceedings, in the civil proceedings. For example, in the Insolvency Act, that one should take into account the rights of the party not to incriminate themselves in later criminal proceedings. But it's specifically in proceedings where there's an element of compulsion, where, where the proceedings of an nature of an interrogation, like in the Insolvency Act. And that's in paragraph 16. And then I'd suggest that...
And is it good enough in law to say, maybe one day somebody might decide to charge me, and therefore I have a right against self-incrimination? Is that what the law protects?
Not. In fact,
could you speculatively say, one day I might be charged, and therefore I'm not going to answer questions?
Absolutely. If I may refer your Justice to paragraph 23 of the judgment, and if I can just quote from it, I think this is the ratio. The court says the following: in my view, after having gone through the case law, in my view, the approach in Davis is sound and does no more than reiterate the approach of the previous decisions, namely that a stay will only be granted where there is an element of state compulsion impacting on the accused person's right to silence. It is true that the judges in those cases do not specifically refer to compulsion, but this is a matter of deduction made from the way the general principle was applied in matters which primarily involved sequestration proceedings. The development and formulation of the principle occurred in the context of sequestration proceedings.
Yes.
There is no authority to support the proposition that the principle is of application in ordinary civil proceedings, not involving an element of compulsion. And that's at paragraph 23 of that judgment. So it doesn't...
The proposition you find in Levine v. Fraser in the Constitutional Court.
Indeed. This is well accepted by our courts. And no more needs to be said about that. Perhaps the only factor that is, the only factor in common between this judgment and the proceedings here is that in that case, Randall was an attorney, was an officer of the court and bore ethical and public obligations as a result. And in this case, Dr. Manamela too, as a public official, bears public duties under the Constitution. If there's any commonality between that set of facts and proceedings and these, it is that they both bear public...
It includes the duty of transparency, the
Section
duty
195.
of accountability.
Yes.
All of those bind every single public official.
That is so, Justice. I'm afraid to say that Dr. Manamela's conduct today is consistent with the evidence that has been placed before this hearing already, which is a violation and a repeated violation. This is perpetuating the violation of Section 195 of the Constitution. And it's not only contemptuous of the arbitrator and of the court process, but it's contemptuous of the families who themselves made themselves present for the hearing. And those are my submissions. I would urge your Justice to dismiss the application in entirety, not only in relation to the postponement, but the late and belated requests for recordings and the like that I've seen for the first time now in the notice of motion a few minutes ago, and to do so with costs. Thank you, Justice.
Thank you. Advocate Krause.
Thank you, Justice. I'll try to be brief. There's just two issues that I want to address at this stage. The first is there's no indication why this must be heard in such an urgent basis. Dr. Manamela caused her own urgency, and therefore on that basis alone, this belated application must fail. The second continues, and my learned friend has touched on this, the issue of the Randall court case. Can I give the court the citation? It's 2013, 3 South African Law Reports, 437, and it's a SCA decision. Unfortunately, I think there's a misreading of this court case, as my learned friend had said. What happened in this court case is that the attorney sought a stay in the local division, and the SCA has overturned that. So the SCA hasn't granted the stay of the civil matter. That's the first point. And the SCA raised 3 issues in my submission, which is important. The first is that prejudice is not a broad issue. You have to show what your prejudice is. And the SCA said specifically, the attorney denies any wrongdoing. So what prejudice could there be in any of these proceedings for him to place his defense on record? And it's same with Dr. Manamela, yeah. She denies any wrongdoing, so what prejudice could there be for her? And the second issue is that what my learned friend has just touched on, and that is the huge public importance of the matter. And for those 2 issues, the SCA had said the matter should proceed. The court hasn't asked again on the cost issue, and I'm very reluctant to make any submissions without giving Dr. Manamela a proper right to answer, perhaps in writing, because we've got the buy-watch principle, but we also have the frivolousness of this application. So for that reason, I'm not making any submissions that this court should make a ruling now. She is not a party to these proceedings. If the court finds perhaps that the state should be reimbursed or that she must make submissions, at a later stage, the court specifically asked her to make submissions, then I submit that would be the proper approach. Those are our submissions.
Well, I have invited counsel to make submissions on costs.
That is so, but just as this application has been wholly unprepared, I submit that perhaps a little bit more should be done in the interest of justice. Court, please.
Very well. Advocate Groenewald.
Thank you, Justice. Justice, I think my colleagues have dealt with the law on the issue, and we stand by our previous submissions. The application is without basis, and we submit that it should be dismissed. It's now 3 hours into the day, and Justice, it's opportunity that we've missed to hear evidence. So, yeah, the long and the short, Justice, we say that there is no legal basis for the application. It should be dismissed. To the extent that the Justice would be inclined to provide the postponement or grant the postponement, we've taken note of the fact that my learned colleague has made no submissions in respect to when they want the matter to be postponed. It's now, we've heard about the disciplinary proceedings, we've heard about possible criminal proceedings. So it seems like it's not an application for postponement, Justice. It's rather an application to set aside the subpoena in totality. That is how we see this. Because although Dr. Manamela says that she's inclined to testify and she wants to testify, she says, well, I don't want to testify now because I have disciplinary proceedings and possible criminal proceedings. So she's not telling us when would be the exact date when she will be available to testify. And the long and the short of the story is, there is a subpoena, she's required to testify, and that, Justice, we submit is the end of the matter.
Counsel?
Thank you, Justice. As we have indicated before the adjournment, there is no indication as to when is the matter supposed to be postponed to. But what we want to submit is that Dr. Manamela's appearance before these proceedings is in respect of a subpoena which has been issued. And it has been acknowledged that such a subpoena was served on the 2nd of November, no steps were taken seeking the type of information that is now being requested. Apart from that, the subpoena itself, it clearly states what is it that it is expected of her. And if I can just read it for the record. The subpoena is attached to the affidavit, which has been presented as Annex C. The second page of that subpoena clearly states that she is required to appear in person before these proceedings today, the 20th of November, at 9:30, in order to testify in regard to all matters within her knowledge relating to the issues before the arbitration, relating to the Gauteng Mental Health Marathon Project, including the circumstances leading to the discharge of mental health care users from the Life Esidimeni mental health care facilities. This much has been made clear from the subpoena itself. It is quite unclear what other information is sought from the witness. And with regard to the aspect relating to the request for the laptop, this much has been canvassed, and it has been admitted by my learned friend on behalf of Dr. Manamela that to the extent that the letter requesting the laptop is dated the 17th of November 2017, that letter was only transmitted on Saturday, the 18th of November 2017. And there's no explanation why has such request not been made soon after the service of the subpoena on the 2nd of November. Be that as it may, the department, after receipt of such a request, has made means to ensure that that laptop is made available in order to assist to the extent that Dr. Manamela requests such a laptop. The laptop will be made available, but what we do not understand is why was such a request not made prior to these proceedings. From the letter requesting the laptop, it requires the department to make that laptop available by midday today, when the subpoena already has stated that her testimony was required to have commenced at least 9:30 this morning. So the timing of the request is just unfortunate, but we have done everything to make sure that the laptop is available, and arrangements of her access to that laptop will be made with the department. We should just put it on record that it is indeed available.
And the record of proceedings, counsel, is it not? The other people have asked for the record of proceedings and other witnesses, and they've been given the record, isn't it so?
Indeed so. Even if the subpoena, which she's been called upon to come before these proceedings, having been served on the 2nd of November, Dr. Manamela was quite aware that there was an attempt requesting her to appear before these proceedings. That much occurred long before the 2nd of November. And we do not get an explanation why steps have not been taken in order to secure it be the record of the proceedings, it be the laptop sought to be relied upon. All that is being sought is that the matter has to be postponed to unidentified date basically, like what is being sought is that like her appearance should be postponed indefinitely because we don't know exactly when will she be ready to be able to come before this proceedings. And apart from that, we should make it clear that it's not about her choice to come before this proceedings. There is a subpoena that has to be complied with.
And you can't set it aside by simply asking for a postponement, can you? And you're a witness and not a party.
Indeed so. She is not a party. All that is called upon her is to testify on matters within her knowledge. That's all that is being requested from her. The request of the documents is neither here nor there. Questions will have to be answered about what she has knowledge of her involvement. And what needs to be highlighted is that she is requested to come before these proceedings by virtue of the position that she is holding in relation to matters before these proceedings. She is the director for mental health Gauteng project. So the subpoena is in relation to that capacity that she's holding so that she can shed light and information pertaining to the matters before these proceedings. And it is on that basis that we would request that the application should be dismissed and she should be called upon to take the stand and deal with matters as and when they are put to her. Those will be our submissions in relation to the application for a postponement. We submit that there is no basis for this belated application.
Thank you, Counsel. Advocate Utamo. Yours is a right of reply, which implies that it will be on issues that have arisen from submissions made by your colleagues. Would you keep it to that, please? We need to proceed.
The first issue will be with regard to the issue of public interest. It had been canvassed that this matter is of public interest. And the picture that is being painted, it is as if my client does not want to testify. I've indicated that my client is happy to testify, however, request more time in order to prepare. And the second issue I would like to highlight is the issue of my client being a director of mental health. Yes, but she was a deputy project manager to these issues, and she was 4 levels behind. There is an HOD, there is a Deputy Director General, there is Director General, and some of the decision are there is a political head. So her duty was actually to ensure that there are things to ensure that the decision that had been taken at the end of the day are complied with. Hence,
shouldn't we hear that from your client? What point are you making now?
No,
you're supposed to address me in reply to the points raised by the other counsel opposing your application.
The point that I'm making is that it shouldn't be one-sided. I submit that it's also in the best interest of justice that she be granted that particular postponement in order to ensure that all the issues are ventilated properly, which is the main objective of this arbitration.
Any other point?
And other issue which I will, because I think there is no prejudice and there is no one to object it, is with regards to the time frame. So I would just like to indicate that as per my instructions that if ever there is any other, for 4 weeks will be sufficient for my client to prepare, unless if the arbitrator rules otherwise, unless if there is less time. So, but that is my instruction.
What do you say to the point which was made by Advocate Vitamo that Dr. Manamela knew even before the 2nd of November that there was an attempt to procure her presence here? And she had therefore more than 18 days in which to prepare herself.
Yeah, with regards to that his submission, and we don't know as to where those submissions are founded. So my submission is that...
No, in the affidavit you've attached 2 subpoenas, the first abortive one and the second one. So counsel simply says by looking at the initial subpoena, she would have known many, many weeks before today that there's an attempt to procure her attendance. And all I'm inviting you is to respond to that submission, if any. You're not obliged to. Look at Annex A of your papers. In other words, submission is he knew a month ago that she said a month from the first subpoena to now. Anyway, do you have any further submissions in reply?
No.
No.
No further submission other than the point that I've highlighted with regards to the issue of the public interest, that it shouldn't be one-sided. And this request for postponement is also to the advantage, which we have highlighted earlier on, that in fact my client is happy to testify. However, this application, Justice.
This morning, at the start of the proceedings, there appeared before me an attorney and counsel who introduced themselves as acting on behalf of Dr. Makgabo Johanna Manamela. They sought to postpone these proceedings in order to permit Dr. Manamela to prepare herself in her subpoenaed role as a witness. Upon the objection that the application was defective, the party, Dr. Manamela's counsel, sought an adjournment, and on resumption, I was presented with a notice of motion as well as a founding affidavit purporting to support the relief sought in the notice of motion. The relief sought in the notice of motion reads as follows: to grant postponement to the applicant being Dr. Makgabo Johanna Manamela, 2, ordering the Department of Health, Gauteng, to release the laptop of Dr. M.J. Manamela, 3, ordering the record of witnesses, I presume that means record of the proceedings or of the evidence of witnesses that have testified before the arbitration, and the application seeks costs to be paid by the state other than further or alternative relief. I've exercised immense patience this morning listening to submissions which have been made to support the application, and I've again looked at the affidavit which has been filed in support of the application. In my view, the application is baseless, both on the facts that it purports to rely on and as well as on the law. And consequently, the application is dismissed forthwith. And Dr. Manamela is directed to take the witness stand immediately. Evidence leader, would you call Dr. Manamela to take the witness stand, please? I should have added that any further reasons, if necessary, will be provided in the full reasons of the award. To all here present, we've long agreed that I will not tolerate any heckling or any jeers, and witnesses provide their evidence. Dr. Manamela should be given all the space and the respect to deliver her testimony this morning, this afternoon, I should say. Thobela, Dr. Manamela.
Thobela, Justice,
Le
Chief
kae?
Justice, re gona le kae?
No re gona mme.
Eh,
O batla go bolela ka leleme le lefe?
English e lokile.
Sekgowa se lokile.
Eh,
Would you put your full names on record, please?
my name is Makgabo Johanna Manamela, appointed by Department of Health as Director.
We will get there in a moment.
Okay.
Let me swear you in. Do you swear that the evidence you are about to give will be the truth and nothing but the truth? And if so, please raise your right hand and say, "So help me God."
So help me God.
Advocate Nguchana.
Thank you, Justice Msaneke. My colleague, Advocate Yina, would lead here.
Thank you, Justice. Good afternoon, Dr. Manamela.
Afternoon.
Will you please state your qualifications for the record? Will you please state your qualifications?
Okay. I am a professional nurse trained in psychiatry. I did masters in psychiatry, psychiatric nursing actually. I also studied at VETS for public health, and I also did my doctorate majoring in psychiatric nursing. And I did other courses in nursing, nursing education, training, community, and other administration qualification I have achieved.
Thank you. Will you also please state your experience, your work experience?
My work experience, I worked in many hospitals, starting with a mental health nurse, then mental health nurse in advanced level, advanced mental health specialist. I also worked in hospitals as CEO of hospitals. I also managed mental health care unit in Limpopo, Tabamopo as the head of nursing years ago, before I came to the position of CEO. I also managed mental health services in all my positions that I was, until I was also managing the mental health, or appointed director mental health care services in the province since 2010 to date.
It is common cause then that during the period spanning from 2015 and 2016, you were the director for the Gauteng Department of Mental Health.
Yes.
And you
Sorry,
said
Councillor, would you repeat those dates again?
during the period spanning 2015 to 2016,
Yes.
her evidence justice that she was appointed in 2010. Am I correct, Dr. Manamela?
Yes.
Director from 2010, but also director during the relevant period,
Yes, thank
i.e.
you, Justice.
2015 to 2016.
Thank you,
I
Justice.
follow that, thank you.
Thank you. Ma'am, it's common cause that sometime in 2015, there was a project that the Department of Gauteng Mental Health embarked on, which is commonly known as the Gauteng Department of Mental Health Marathon Project. Are you familiar with that project?
I'm not familiar with the name of that project, but I'm familiar with the project that was termed termination of contract between mental health care services between Gauteng Province and Life Esidimeni. And having been stating that, if it pleases the judge, I would like to first take you through before I can answer all your questions through what happened, all the event chronologically, before I can answer the questions.
You may please. If you could repeat the name of the project according to you before you start. What was the project according to you? What was it called again?
The project was never called Gauteng Mental Health Marathon Project. That was not the name of the project. Everyone who took part in the project, including the ombudsman, before I go to ombudsman, input in the project and into the name of the project. And the project was termed termination of contract relationship between Gauteng Department of Health and Life Esidimeni, and upscaling of community-based mental health services. That is the name of the project that I know. However, marathon, within this project, there was a marathon, NGO marathon project that maybe I'll take you through later. But this is the name of the project, input into by all the project team that were appointed, including the leadership of the department.
And it's the same project that was conceived in 2015 and executed in
Yes,
2015 and
it's the same,
2016.
it's the same project.
Yes, please go ahead.
But just before you do, Doctor, tell me the hierarchy. I just want to understand where you sit in the order of management hierarchy.
Okay, thank you, Justice. Where I'm standing, I am the director. There is the political head in the department who assists in making decisions that are relevant for politicians or
You were
political
director
services.
of a particular
I
part
was
of the
a
department?
director of mental health care services in Gauteng Province.
Yes, thank you.
Before me, I was reporting to the chief director, hospital services. And also she was reporting to the deputy director general, clinical services.
Who was the chief director at the time?
At the time, the chief director was reporting to on my mental health care services was Dr. Mazamisa, but the chief director was reporting to in relation to the termination was Mr. Museno as the project manager.
In the normal course, you report to Dr. Mazamisa,
Yes,
but on this
Justice.
project, you reported to Mr. Musenohi.
Yes, Justice.
Okay, take me up the ladder, and then you can tell us what happened. And who's then the person you'd report to beyond the chief director? Or to whom would the
Okay.
chief director report?
The chief director reports to the deputy director general, clinical services. And then the deputy director general, clinical services.
Who was it?
During the process, it
2015,
was
2016?
Dr. Libet.
Dr. Lebeta. Right, let's go up the ladder.
And Dr. Libete will report to the head of the department, who was Dr. Silvano, who will report to the political head, the Mahlangu.
Thank you. Please proceed. You want to just tell us the story in your own words, and thereafter counsel will then ask you questions as she may deem necessary. We are listening.
Yes, Council. I must start by saying I'm saddened by all the death that took place in our services. And from the first day that I heard of any patient who died in the first NGO and including the hospital, I was devastated, and I felt that pain that anyone who loses the parent or the loved one will feel. And I have no better ways to can explain the pain and that hurt, and the anger based on how things was unfolding during the process that the family might have. And I know it was a difficult time for the family. But the summary that I will give to these proceedings will try to clarify all what has happened. Gauteng Department of Health had a service level agreement with Life Esidimeni for a period of about 36 years. I think you all know about it. And it terminated its contract relationship during 2015-2016. Like all other mental health services in the province, I knew when we had the pronouncement, even before the termination letter was sent, that that process will fall within my unit. And I have some few documents for the justice that I have attached that indicates when the termination letter was sent, it was in line with the service level agreement. As is stated in the service level agreement, is attached here as Annexure 2.
Justice, if I may, please. Dr. Manamela, usually this arbitration would give witnesses an opportunity to state whatever they want to state at the end of their evidence. It will assist you if you allow us to lead you by way of questioning, and then if you want to add more clarity, you can do so during the questioning, and also at a later stage, if you feel like there's something that we omitted or that you want to state, you can do so. In that way, your evidence will be more structured, if you don't mind.
Thank you. I think I mind, because I want to give you what has happened, and then you will ask me. I will still go back if we still need clarity. I don't want to be in a situation where I will touch there and there. So if I put it, I didn't put a lot. It's just to give you clear. I know you are all aware of what happened in terms of termination. I might be boring some of you, but I wanted you to get it from me, because I was also part of the project team. So I'm not reading each and everything. I'm just touching things that I think are important, if I'm allowed.
I am on the side of the witness on this one. I want to allow the witness to say it like she knows it to be.
Thank you, Justice.
And I ask you to track all that and go back and fill up the gaps as you deem necessary.
Thank you, Justice.
It is not always unuseful to hear the witness tell her story in full, and of course the questions will follow.
Thank you, Justice.
So I allow you to proceed the way you find it convenient, Dr. Manamela.
Thank you, Justice. I've also tried to answer the questions that I've had over this proceeding, although some I couldn't hear them, but pardon me if I mention my answers to mischaracterization of the facts that were indicated. For example, the first thing that I should have said to this, it was that on the 9th, when the Professor Malagapuru, the Ombudsman for Health, presenting, he has indicated that when he was asked about the records and the document, he has indicated that I had a plan that was not signed. I didn't use that document. I only used the witness information. And that explained to me why he didn't name the name of the project properly, but took a certain a strategy within the project like an NGO marathon and use it as Gauteng a mental health marathon. I said I'll go to the NGO marathon, explain to you what was it all about. But that also explains why. Because if we give evidence, we gave him verbal evidence and also gave written evidence. The written evidence that was signed, which was also included here for the judge as Annexure 6. So after the service level agreement was terminated, we are all aware that the MEC has been talking about it in the media, but maybe before I can say that, when the department, most of the people who were here knew that the department was under very financial constraints. At a certain stage, on every year, we'll go and reprioritize the service of the department. It happened that in the financial year 2015-2016, when the reprioritization was made, there were a lot of some constraints, and the other areas were looked into, and it was found that some of the areas will have to have more constrict management of finance, or try to see how we can manage the issue. Present the budget speech of 2015-2016, where he said, I quote, we have the cost containment initiatives by reviewing outsourced services. That will include Life Esidimeni, because the services was for department, not done by department. In particular, those who sell for step-down bed facilities and Life Esidimeni for long-term psychiatric beds. The second point, with regard to Life Esidimeni, the department has already commenced with the reduction of the number of beds by 20% in the 2015-2016, with the view to exceed this arrangement at the end of 2016-2017, which was the last year. And the MEC was all vocal in the media, everybody was hearing that. And considering the above, as the Director for Mental Health, knowing that the work that the MEC has pronounced will fall within my unit, me and my team, we had to commission a task team before we go to project team. And the task team was including...
Sorry, was the budget speech in Parliament, in the legislature?
Yes, it was in the legislature.
And it referred to Life Esidimeni?
It referred to Life Esidimeni.
Please continue.
And even before that, during early 2014, towards the end of 2014-2015, when we closed the budget, around January, it was also... we also... A letter was written to the Premier to indicate that we are going to reduce the bed of Life Esidimeni by 20%. And that was informed by the Mental Health Strategy 2020 vision, which we developed after we have given the mental health policy from the nation, from the national. That strategy was saying Life Esidimeni had to reduce the bed on a yearly basis by 200 beds. And the very same year, as we were closing, we still had problem in Life Esidimeni to have money to reduce bed, because mentally ill patients at times, they come and go and come again. So we still had that. Unfortunate for us, there was a dispute about the 20% that was informing Life Esidimeni to reduce the bed, because they were still working on the 200 beds that we were working on. Thereafter, they declared a dispute, and the dispute was resolved. We carried on. We carried on with the task team, which I was leading at that time. In that task team, there were Life Esidimeni managers, there were clinicians of the department representing all the hospital, psychiatric hospital, there were clinicians representing all the community mental health care services. However, in the beginning, the task team is also attached in here for the judge. In the beginning, the task team, we realize, we look at the reduction and where will, if this patient, because some of them will go back to Life Esidimeni even when discharged or when in the NGO. So we started to plan. Our plan from the beginning included infrastructure unit. We had Mr. Kubindlela, who was assisting us with the renovation so that we renovate the hospital, we renovate the and C, we renovate the old hospital that were not being in use. So they were part of the task team. I must state that during the task team, Chief Justice, it was not so easy for everyone to realize that. However, MEC had a meeting every Friday with the CEO where I was not part. It happened that as she met with them and explaining things, the CEO of hospital managed to understand better the termination process. And they came
Who
back.
had the meeting, the MEC?
MEC used to have MEC Matlangu used to have meeting for service delivery every Friday, improvement. So the CEOs of mental health unit were part of that. So they helped that their psychiatrists also understand the process of the termination. And during that time, there were minutes there, here. I know they were giving me tough time as I was the leader of the task team. And there were actions that were supposed to be done. To the unfortunate part, as we were studying, we were still a task team. Then when we discussed everything from the meeting, we noticed that some of the information will be out. And some of the information, for example, we had 5 hospitals that are not used that we wanted to renovate so that it can be used by NGO. We applied for that, and then the people were helping.
We've allowed you to speak to free will, so to speak.
Yes.
But like all stories, when you tell them, you've got to tell the timelines.
Okay, thank you.
Please. In
Thank you.
November this year, wara.
Okay.
In March this year, so that the story flows in a way that we understand.
Okay, between March, between January,
That's
February.
the work of evidence leaders normally, but I've agreed that you say your piece and be asked questions later. But
Okay.
help us with dates and names in a clear way so that we all follow the evidence.
We have started with this meeting around end of February, March, the task team meeting.
And always mention the year.
Yes, 2015.
Thank you.
And during this meeting, like I mentioned, the task team people, including Life Esidimeni managers. During this meeting, we identified what we need to do and hospital that we need to renovate. From that time until June, we're busy with that. During the process, as I said,
Until June 2015.
until June 2015.
Every month, please add a year so that we can have the chronology clear.
Yes, we.
For all of these council who are going to be asking you questions. Thank
Yes,
you.
until June 2015, we're busy with this project of task, as task team. And because we had what is going to happen. And during that time, I must admit that the clinicians had so many concerns, and some of the things that I couldn't ask, I refer them to the MEC to write, to meet the MEC or the leadership of the department, which they wrote a letter, and that letter was in April, was directed to me. I'm not sure, I've forgotten the date, but the letter is here, and CC to the executive, knowing that I was not part of the executive. And the team worked together for planning and everything until we meet the HOD, and during the meeting, that's when we meet
I
the
apologize
HOD
for
after.
interrupting. Justice, we don't get the transcriptions immediately in the morning, so it's necessary for us, knowing that this witness will also still continue to take notes, and at this pace, it's absolutely impossible for us to. If the witness could just speak a little bit slower, that we can take notes. Thanks, Justice.
That's a fair point. You're asked to speak a little slower so that council can follow.
Okay.
The normal, so they can take notes. The normal procedure is for you to be led.
Okay.
I have
thank
ruled
you.
that you say your story. It's a big and important story. And after that, the evidence leader will go back and carefully take you through the gaps that might still be there. But we ask you to take your time, take a deep breath, and tell us with dates and times and places and names what happened. Very
thank
well.
you.
And remember, just to keep it slow so that we all can assimilate it. You are a very important witness. Proceed.
Okay, thank you, Justice. I also have to mention that during the task team meetings that we had, it was clear that Life Esidimeni managers who were part of the task team were not in favor of the termination. And the leadership executive leadership used to have the meeting from around April, I think before April, led by the MEC. I'm not quite sure of exact date.
Who are not in favor of the project, the managers?
The managers that are at my same level in the meetings that we had, we could detect that they are not in favor of the termination of project. And when during the process, as the Life Esidimeni had a mandate to reduce the bed by 200, according to 2020 vision strategy, they managed to reduce the 200 beds during the process before end of September. So at the time of the end of the September, when the notice was issued to Life Esidimeni, they've already closed
that is September of
2015.
Right.
Yes, they've already closed one of their facility called as vet board. There were no patients there because most of the patients were discharged home. Some were taken to the NGO on the normal process, because I should mention that during the process of us and Life Esidimeni, there was a process that they will send the patient to the NGO. And that process was that when they are patient to be discharged, the NGO will go and identify which patients are the patients that they are managing, those NGO that we had contract with. So then after the termination letter was issued, the project team was appointed. And Mr. Musenu, who was the leader of the project, I had in this proceeding
when was he appointed? Again, dates and
he was
places.
appointed around October during our
October 2015.
2015. I will say so, but I think it's because immediately after that, if not beginning of November, it was end of October 2015. And when he was appointed because of his role as the executive. He was not appointed because I failed in my duty for mental health services, as it was said by the UMBAs in this proceeding. And when immediately after he was appointed, he commissioned the project team. That is what we've been looking for. And the project team members were appointed, and their names are also in the document, and that included all the psychiatrists in our mental health care unit, including some of the psychiatrists who are heading the district on mental health services. That document is also here. And they are the one, by the time they were appointed in November 2015, you could see that immediately the termination letter was given. We have started ourselves in my unit and the psychiatrist with the plan. And then we just needed the project leader. And then when they came, they are appointed, they were given the project draft to look at. And they commented. And there were some, if you look at what we termed as the project task team name, it's not the same as the project name. That's when we had the project name termination of contract relationship between Gauteng Department of Health and Life Esidimeni, and also upscaling community-based mental health services.
Okay, doctor, take it slower. Take it slower.
Mm-hmm.
It's a long, important story, but just take it. I know you know it all. You have it in front of you, but just take it slower. And you have a copy of the draft project plan. in writing
Yes.
with you there?
The-
Okay, you proceed. I'm sure they'll come back and
Okay.
ask for it.
All right. The project plan was indicated there.
Yes.
And I will
We're
say,
at November 2015, the project team put together,
yes,
and there was a draft which was made available to them.
yes,
Let's proceed then.
yes. And I must also say, it was untrue that the psychiatrists, and they were not part of the process, because the team worked together and arrived at the name, and we welcomed the name and started to use the name. And during this process, now I was no longer leading this team of psychiatrists, because I was leading the psychiatrists together with the infrastructure. During this process, we had to get the project team to lead, and the meetings were held, managed, or led by either HOD, MEC. Actually, it was termed the MEC meeting. If she was not there, the HOD will lead the project. And after the very same termination letter was issued in 2015 September, we invited the NGO because we knew they would be affected. We invited the hospital, psychiatrists, and the multidisciplinary team members during the very same, during November, to know, because we knew they would be affected. And in the meeting, I'll start first with the NGO. We gave them the information, told them that there will be termination by the end of the 2016-2017
That goes
financial year.
fast.
I'm
We
still
avoided
fast.
you being led, but we're getting confused now. November
Okay.
2015, you talk about NGOs. You had a
Yes.
meeting with NGOs.
Yes.
Tell us who convened the meeting, where was it, when was it? Every time you tell a story, like a bedtime
Okay.
story. Okay.
All right.
November 2015,
November
the project team decided to meet with NGOs. So-and-so convened the meeting. It was chaired by so-and-so, and we said this to the NGOs. Just logically, slowly, let's follow the tale.
Okay, thank
Please.
you. Just after the termination letter was given, we commenced properly with the project team
Yes.
from November. Led either by the project leader, I was always deputizing him, and also with the 2 weekly meetings with the MEC to give progress. Then
And every
during
time
the
you
process,
say MEC, you mean MEC
MEC, the former
Mahlangu.
MEC Mahlangu,
Yes,
because I
okay.
haven't worked with the new MEC now.
We follow.
Yes. Then we realized that we need to inform the NGOs, because we know that there are a lot of patients in our Life Esidimeni facility, and some we pick up in the community that doesn't have families, and some have families, but the families doesn't know how to take care of them because of their condition. So what we did, we met with the NGO and made a presentation to them to say those who are willing. We called all the NGOs that we know, we work with, that are licensed during the process, and even the NGO that doesn't have patients, like SADC and others, and South African Federation, they were in a meeting. Then we presented to them what is the decision of department. The meeting, I think, was
Where
in
was
13
When? Where?
November 13 November 2015. The meeting was at Sterfontein.
Yes.
That meeting was chaired by myself as the Director for Mental Health Services, but there were my deputy directors who had to present what they are doing. For example, in my directorate, we are having someone responsible only for NGOs, because we had over 110 NGO in this province. So they needed someone who lies with the district to be able to support and guide the NGO. We also had someone who is specifically responsible for mental health services in our own hospitals. We also we still have, I believe so, 2 more deputy directors who were responsible for mental health care services in the community for those who were discharged. And we also had a social worker who also support all of us. So during this process, we also noted that we need to have other stakeholders in our meeting, such as SADC, such as South African Federation, to work together with us, because they've been working together with us anyway. We can't leave them as out.
South African Federation
of Mental Health Care. And we look at that, and then they were also invited in the meeting. The other meeting that I can also indicate was the meeting with the family. But before I'll go there, I think I will need to go into detail with that. Let me say that in the project plan, the Life Esidimeni project task team, the Life Esidimeni manager were tasked with some duties, for example, to go and give us the patient profile for us to know how many patients we have, who should go where, who should not we go, and how do we advise maybe the leadership to say this patient cannot go anywhere or not. So during that time, they have given us the list, the profile. I will just mention that amongst the issues that they highlighted in the profile, we noticed that there were 773 patients who are in Life Esidimeni who doesn't have families. And there were, at that time, 1,200 patients had family contact in their document, but they were not visited as they were supposed to, but they had family contact. And when we check with them, the reason was that sometimes the family contact numbers are changed. Some family will move to a certain place. For example, I had a gentleman who, during the process, who called me from overseas, and the mother who called from overseas to say, I hear that there will be termination. Where is my brother going? So and so and so, and they were also assisted. And apart from that, involving stakeholders, like I've mentioned, we started as task team, and I was chairing the meeting. But when the pronouncement was made for termination, it was also, I must clearly indicate that it was also indicated that the stakeholders were not so keen in termination. Then there was a little bit of a problem. Then we asked the HOD to lead the meeting. At the end of the day,
I think you have to help us there. Who are stakeholders you're talking about?
Oh, stakeholders I'm talking about, I said, is SADC, is South African Federation for Mental Health Care Services, because they are the one who are specifically dealing with mental health care services. And their involvement was key to us. That's why we started without the request by the HOD. And then later when we realized that it's like we don't go where we have to go, we asked the leadership to take over. Why I'm saying this? Because there was a media that was released that was saying by SADC, I'm not having the details of the date, but it was saying we are going to take patient to Jamestown Hospital. They phoned Jamestown Hospital, there is no board. And they phoned Old Natasbred, there is no board, because they didn't know that we were going to renovate first before we send. And then they phoned the CEO of the hospital and asked about the bed. And the CEO also, during that time, around September, they didn't know of the bed.
Dr. Manamela, thank you. It's 1:30, and I intend to take the lunch adjournment now to 2:30. But let me leave you with this thought. It's a rare privilege in a court to allow a witness or an arbitration or judicial proceedings to tell their story the way they know it, and I'd like that to happen.
Okay.
When we come back, please think about that. If it doesn't happen properly, I'll have to turn you over to the evidence leader. She's trained in the work. She knows how to get a witness to tell, to render or to tender evidence. Normally, we need times and places and events in a particular way that allows everybody to understand what happened and how it happened. And the advocate who's going to ask you questions is very skilled in that regard. It's her work to make sure the witness gives us evidence in chief. So think about it. When we come back, you'll be allowed for a while to tell the story. Please remember, we require dates, we require the year, we require the place, we require the people, and what happened. Those are the basics in all evidence. So unless we get the story that way, we'll have to find somebody who will help lead you in chief so that we can get the full story of your participation. But thank you so far for what you've told us. We're going to adjourn for an hour, and when we come back, we have to continue. And if we go along in that open-ended way, I'm going to ask the advocate to actually pose questions in chief, which is different from cross-examination, but it's to get the whole tale properly recorded. I thank you. You're expected to be back here at 2:30. We are adjourned.